Welcome back to the podcast, the Law Podcast Uganda. Thank you, those of us who are here, and thank you for keeping it here. We are here to make sense of the law, simplify the law, and to make sure that all of us understand, especially the basic things in law. So today, I have come to talk about, and by way of introduction, for those of you who are just joining us, my name is Alex Kafero. I'm an advocate of the High Court of Uganda. In other words, I practice law. It's what I do for a living, really. So now today I want us to talk about one of the most important things, and that is the property of a dead person. You know, death is always with us. And during our lifetime, we acquire or accumulate wealth, properties, and problems usually happen when we die and we leave our property behind, and relatives and friends behind. And so the question becomes, how do we deal with a dead person's property? And you've heard people saying, others fighting, others killing each other, just because of that. So I want us to talk about what the law says about property of a dead person. So here's the thing. When a person dies, they cannot administer or they cannot determine how their property is going to be dealt with. What you can do, or in other words, the only way through which a dead person can administer or say or determine how their property should be dealt with is when they are still alive. And how you do that is by making a will. So the first way of dealing with a dead person's property is by making a will. Wills can be made by a person before friends. However, it's advisable that you go before a lawyer to make a will, because the law mentions or says how a will shall or should be written. It cannot be written anyhow. Why? Because we need to be sure that this will was written by the former owner of that property, and these were his or her wishes. So because of that, the law has created ways through which or how a will should be done. We may not have the time to talk about all that in this podcast, but if you find a lawyer, that lawyer should guide you in how a will should be written. But for starters, it must have the signature of the person making the will, or a thumbprint, or a name, and it must have two witnesses. In law, we call that attestation. Those two witnesses must have seen the will maker making it. So that's very important. So the second way through which a dead person's property can be dealt with is through a grant of letters of administration. So letters of administration usually, and this is the most common thing or way of dealing with a person's property. Why? Because most people don't like making wills. And those of you who are watching this podcast, I need to advise you, although I'm not supposed to be advising you legally from here, but let me do this for you. Kindly take it upon yourselves to make wills, especially those of you who have been lucky enough to accumulate property. Make a will. It does not mean you're going to die. No one knows when you're going to die. We just know that we all have to die at one point, but we don't know when. So please make a will. But anyway, so letters of administration, usually this one happens, this one is granted by court because there is no will. Sometimes, and I don't want to confuse you at all, there are times when a letters of administration can be granted even with a will. And in that case, we say that letters of administration with the will annexed. It's important. Why? Because then how the property shall be administered shall be in accordance with the annexed will. Where the letters of administration are not granted with a will annexed, the administration there is done by the administrators in any other way. So in other words, they can sit down with the beneficiaries, they can, sit down as a family and see how to distribute the property. But here, letters of administration therefore means that the ones I've started with means that there is no will. The person leaving the property, the dead person did not make a will. So here the process starts with going to the LC1, LC3. So LC1 gives you a letter. First of all, in that letter, you must specify that the former owner of the property is dead. You must have a death certificate. You must also, from there, go to the LC3. At the LC3, which is the division, the other places it's a sub-county, you have a meeting, a family meeting before the cow, for the cow to confirm that the person died, the person left A, B, C, D properties in these areas, and also the person's supposed to benefit from this person's property. It's important. And then for the beneficiaries thing, let me just say, a beneficiary does not necessarily mean only the children of the deceased person. No, actually, it can also mean a friend. A friend can be a beneficiary. A distant relative, a person who has been dependent or depending on the deceased person. For instance, I may wish to start, paying school fees for a neighbor's child. I feed the neighbor's child, I pay their school fees. Literally, I'm their guardian, I'm their parent. So in that case, that kid or that person qualifies as a dependent relative. And such a person can benefit from, is a beneficiary or can benefit from my estate. The estate means it's a legal term for the property left behind by a deceased person. So that correction is very important for you to note. Not every beneficiary is a child of the deceased. It can even be a sister, it can be an uncle, it can be, that kind of thing. Therefore, so we go to LC3, division, we have the family meetings, the minutes are handwritten or they are typed, they are signed, all members in attendance are sign and write their names, appointing a person they want to become the administrator of the estate. It can be one, can be two, can be three, can be four. So those minutes are then taken to the Administrator General's office. And why is the Administrator General's office important or necessary in these things? Why? Because the law or the government has set up that office to be the government representative in issues to do with administration of dead people's estates. In fact, you'll find that when you go to the Administrator General's office, you'll have meetings. The lawyers there will have meetings with you, they will guide you, they will ask you what the beneficiaries, who are you, to establish and to ensure that there are no wrangles. In fact, they also end up being mediators. Some families, in fact, sorry to say, but I think most of the families that go to the Administrator General's office have wrangles. The Administrator General and the people working there end up becoming mediators to resolve certain issues. Who is to become the administrator and why? Because it is from that office that you will get what we call a certificate of no objection. Certificate of no objection is one of the things, together with the minutes, the LC letters, the death certificate, that you're going now to present to court, together with what we call a petition for letters of administration or an application for letters of administration. Like we said, letters of administration are granted by courts, which means you have to go to court through an application or a petition. Now, if you don't have a certificate of no objection, you will not be granted letters of administration. Why? Because the court cannot proceed without that certificate of no objection. Therefore, so after getting that, you have to have it, then present that together with a petition. Now, with that petition, the court will invite those people who have been appointed, who have been selected to be granted the powers of administration. See, what you do as a family, you select a person you want to become the administrator or the person to whom you want the letters of administration to be granted. Now, when a person is granted those letters, the court, when the person is selected, before the court grants, the court would want to see that person. So it's what we call identification. So the identification happens, You have to present your national ID, you present your passport photo. An advert is even run in newspapers across the country, newspapers that have a wide circulation like Monitor, New Vision, Bukede, any of those newspapers, to ensure that there is no one out there also applying for the same letters of administration over the same property. And in any case, if there's anyone objecting to your application for the letters of administration, that person has the opportunity to read the newspaper and come to court to challenge. When they come to court, they will caveat. They will caveat the grant and present their reasons to court why you should not be granted letters of administration. So, we assume that all has gone well. You're granted letters of administration. But there are circumstances when this person, the person you've selected, turns around. I mean, it happens. Turns around and starts, doing things that you don't want. He's not distributing the estate, the property. And even when he's distributing to his girlfriends or boyfriends, something like that. People don't understand. People are not beneficiaries. And I mean, they're not doing what they're supposed to be doing, what you wanted them to do. In that case now, the law allows you to go back to court to challenge those letters of administration, or to do what we call revocation of the letters of administration. In other words, whether the person has been given powers to deal with the property of the deceased person, those powers can still be challenged or taken away from them if they abuse them. That's very important. So for you to know, I have seen and I've had cases where people think that being granted letters of administration makes them kings. No, you're not a king. Actually, you're just granted those powers for a given period of time, not exceeding 3 years. And actually, you must demonstrate to court that you have distributed that property and even make an account of the property of the deceased person that you have distributed and how you have distributed it within not more than 12 months. So within 6 months, you must represent what you call statement of account, or an account, and an inventory. Some of you have heard of them, but if you've never heard of them, this is the right time for you to hear and understand the inventory. So the inventory and the account must be taken back to court. In fact, non-presentation of those two documents can lead to the revocation of letters of administration. It's important. So you must execute that work. And you see, when you get letters of administration, you cannot say, but now I got the letters, I have the powers, I can give them to another person. Letters of administration, ladies and gentlemen, cannot be assigned, cannot be delegated, cannot be, you cannot pass them over to another person to do that for you. No, why? Because those powers are specifically granted to you by the court. See, so therefore, what I want you to take from this podcast today is to understand that when a person dies, his property must be dealt with in accordance with the law. That's the first thing. So 2, that for us to get those powers, we must go to courts. It's very important. 3, you must understand that when you get the powers from court, you must do what is expected of you within a limited period of time. Letters of administration or powers of administration to administer an estate of a deceased person is not intended, or they are not intended to be there forever. No. You say the maximum period is 3 years. But even before the 3 years, you must bring to court statement of account, must bring to court an inventory showing how you have dealt or you have been dealing with this person's property. So the other thing is, I need you to understand that it is very important to go to the Administrator General's office, the importance of the Administrator General's office in this process. It's very important. From there, you get a certificate of no objection. When you go there, a file will be opened and they'll ask you to bring all the documents I've told you to. I've told you about the national ID, the passport photos, the death certificate, the family minutes, the LC letter. All those things show that you are dealing with the right person. So therefore, you see, it's a lot of, the law is always wide. The law is always wide. But on the podcast here, we don't have the time and pleasure to discuss everything in detail. In fact, if we did, we wouldn't be here on this topic. We'd still be discussing the more topics. So, ladies and gentlemen, allow me to stop here today for that. And next podcast, we will, if there are any issues that come up, like we have always said, if there are any issues that you want us to highlight more or highlight further about, you can always put it in the comment section, and also share the link, share the podcast, so that every one of us can benefit from these very good very good words. So thank you for watching. Keep watching the podcast, and thank you.